At this time, I would like to introduce Stephen L. Sugarman of Stephen L. Sugarman and Associates, our presenter. Thank you, Steve.
Thank you very much, Donna. Appreciate the opportunity to participate once again at one of your fabulous roundtable events. Thank you, CAMCO, and your colleagues who spearheaded this particular program. I'm certainly happy to be here. I also see a lot of familiar faces. So either that means that they are not tired of hearing from me as legal counsel for the associations, or maybe they think they've got some more to learn. In either event, welcome for all those that have worked with me over the past number of years, and appreciate your chiming in. This is going to be an interactive program. I'm not standing here to lecture. I'm going to give you that admonition right up front. That this topic, when Donna had called me about it, I said, this topic is perfect for having an interactive discussion, a so-called roundtable event, even though obviously we're here via Zoom and we're not sitting around literally around a table. I'd like you to think as best you can that you're sitting around that table and having a discussion in the living room or in your boardroom, wherever you may be, because really this topic cries out for this type of discussion amongst all of you, board members, managers, whatever hat you might be wearing this evening. We do want to hear from you, your thoughts, your observations. I'm here to answer your questions, and hopefully at the end of the program, you'll walk away with some better insight into what this concept means when we say fiduciary duty. You know, what is that? We hear it all the time. Board members, you have a fiduciary duty. You know, I call it the F word. It's scary. I mean, what is it? And where is it found? I mean, is it something that's just a judicially determined concept? Is it intended to try and control board members in some fashion? What is it? And where is it found? Let's start with the latter question. Where is it found? I mean, is it made up by judges, by lawyers? If you can turn to the next slide, Chrissy, we'll try to answer that question. Certainly it is based in statute. All right. What statutes are we dealing with? When we're here in the community association arena, we're talking about three basic statutes. I have two that are set up here dealing with specific condominium communities and planned communities, also the Cooperative Act. I don't know, is anybody here that's a member of the board of a co-op? There we go. We have at least one. Okay, thank you. That's another statute that governs community associations in Pennsylvania. As I'm sure all of you are aware, we have three separate statutes: Uniform Condominium Act, Uniform Planned Community Act, dealing with homeowner associations, and the Real Estate Cooperative Act, dealing with co-ops. In each of those three separate statutes, there is a specific provision which lays out this concept of fiduciary duty. So to answer the question, where does this come from? It's rooted in statute. Number one, the three statutes that govern common interest ownership communities in Pennsylvania. Two, for those communities that are nonprofit corporations. How many of you know whether or not your community is a nonprofit corporation? Okay, I see a lot of hands. Well, many community associations are, but under each of the three statutes, again, UCA, UPCA, and the RECA, dealing with common interest communities here in our Commonwealth, you need not be a nonprofit corporation to function. You can be an unincorporated association and still have all the attributes of a bona fide entity under Pennsylvania law by virtue of the statutory underpinnings of community associations. But if you are a nonprofit corporation, you also have the benefit of the nonprofit corporation law in Pennsylvania, which governs nonprofit corporations, such as your community association. And there are specific sections that apply directly to your community association, including, without limitation, as we say in the legal business, 5712 of the nonprofit corporation law, What does that spell out? It spells out the same fiduciary duty that is embodied in the sections that you see in the slide. 3303A, 5303A of the UCA and UPCA, respectively. I would urge all of you, if you do not have copies of these sections of these statutes, get them. You can get them, you can download them from our firm's website. You can get them through the internet generally to do a Google search. But I would urge all of you to have this statutory section by your side as a board member at all times. I cannot overemphasize, and you'll see in a few minutes as we go further into the slides and our discussion, you'll see why it is absolutely imperative that you become very familiar with this concept that's embodied in these statutes. Know the actual language, because it will serve as a very helpful guide for all of you in figuring out what your standard of care is as a fiduciary on the board of directors of your community association. Let's go to the next slide, Chris. Your governing documents may also be the source, or a source, not the source, but a source of the fiduciary duty. Many declarations and bylaws have an express requirement for board members to conform their conduct based upon those same statutory sections. In other words, that you stand in a fiduciary relationship to the association and that you are obligated to perform in accordance with that statutory section. So you have the statute laying out the fiduciary obligation, and then the governing documents, which generally speaking incorporate those same statutory provisions. Next slide, Chrissy, please. All right, now we get to the good stuff. That's the backdrop, the sources of authority. Let's talk about what this fiduciary duty is. Anybody have a thought? Anybody want to raise their hand and describe your perspective of what it means to be a fiduciary? Again, it's kind of an awkward word. It obviously means you stand in a trust relationship, but it's more than that. And it is a high standard of care. What is a fiduciary? Anybody want to volunteer? Again, we're trying to make this somewhat interactive. Have you given it any thought? I mean, I'm sure you hear this concept all the time. And one of the reasons Donna asked me to talk about it tonight. But did you ever actually distill in your minds the concept and what it is that you have to adhere to in order to discharge or satisfy your fiduciary obligation as a board member? Anybody have a hand raised? I don't see everybody. Ah, there we go. Harold, if you can unmute yourself. Thank you.
Your fiduciary responsibility makes you a steward of the finances of the corporation, of the co-op.
Right. All right. So certainly you have certain obligations as steward, as Harold put it, of the finances. Is that it? Is your responsibility limited just to the financial affairs of the association? Arthur.
Oh, you're on mute, Arthur.
You're on mute.
Unmute, please.
There we go.
Am I unmuted now?
You are indeed.
Okay, well, Steve, you actually have on the screen exactly what the duty is.
You're cheating, Arthur.
To act in good faith in the best interest of the association with reasonable inquiry, skill, and diligence as a person of ordinary prudence. So you have to act like a reasonably intelligent person, doing due diligence and acting in good faith to come to a conclusion as to what the board should do in a myriad of situations.
So not just limited to financial affairs.
Oh, no, it's all the responsibilities that a board would have. You have to conduct yourself in that manner.
Okay. Well, what does this, and you're correct, what you see here in number 2 are actually the terms that are set forth in those statutory sections to which I referred at the outset of this discussion, that you have to act in good faith. What does that mean? In good faith? And what does it mean to say in the best interests of the association?
Well, this is how, Steve, I interpret good faith. Good faith is you have, let's say in our association, we have 77 units.
Mhm.
So you have to act in the best interests of the significant majority of the unit owners, and not in your own interests. So you have to put your own interests aside and say what is best for the community at large. And then you have to try to, look at the facts and determine with the rest of the board what is really in the best interest of the entire community.
And I want to thank you, Arthur. I want to emphasize Arthur's comment about to whom the duty is owed, and a very, very misunderstood concept, not just amongst board members, but I can tell you amongst lawyers as well, that the duty, this fiduciary duty that we hear so much about, and it's the most important duty that board members have, it is owed to the entity. It is owed to the association. And you can see in number 2, in the best interest of, not of the board, not of the members of the association, not of the vendors, not of the management company, not of the attorneys for the association. It is the good faith acting in the best interest of the association. So you can certainly see where there may well be situations where the board is going to say, well, the majority or a good number of members want to see this change. We want to change the scope of the maintenance responsibilities. And the homeowners want to take on less responsibility for certain exterior maintenance. But it may not be in the best interest of the association. Why? Because the association is going to have to generate additional revenue to expand the scope of its maintenance, repair, and replacement responsibilities. So you may have a situation where the owners might like the idea, but at the end of the day, is that really in the best interest of the association? And who's going to fund that expanded obligation or responsibility? So there are many times situations where the owners may have a certain either emotional belief or a certain desire that may conflict with what is actually in the best interest of the entity. As a board member, while certainly you need to have your ear to the ground and be responsive to members' concerns and members' comments, at the end of the day, your responsibility is owed to the association. And there would be indeed a breach of that fiduciary responsibility if you applied a standard that you were following the direction or dictates or desires of the members and not following what you may conclude would be in the best interest of the association. So again, association in essence is your client, like an attorney-client relationship. You have to act on behalf of and in the best interest of the entity, not be pulled and tugged by what you might hear from your homeowners who may have a certain perspective, but it may ultimately not be in the best interest of the association. Good faith, another critical concept. And these are the kinds of terms that you'll see litigated often, and jurists are oftentimes kind of juggling these concepts around. What is good faith? Well, just classic example, if you're getting competing bids from landscapers and the brother of the board president happens to have a landscaping company, and that bid may be a higher bid, but the board president, who kind of attempts to strong arm other board members, say, well, no, my brother's great, he does a super job. Yeah, the bid's higher than the rest, but trust me, he's a good guy and you'll get good service. You have to take a look at that. Are there conflicts of interest here? Might it be in the best interest of the entity to flush out those conflicts And if there are personal relationships with some of your vendors and contractors that may give pause for whether or not that's actually in the best interest of the association, because you could be challenged as to whether or not the decision-making process was done in good faith, if there is some sense of some bias or some prejudice or being pulled in a certain direction because of personal interests. You know, likewise, our board members, do board members benefit from a decision? Let's assume that you want to change the percentage interests because the board members feel they're paying too much on assessments. And while you still may need 100% approval, if this is being pushed by board members, all of whom are going to benefit from the change in the common element interest because their assessments will plummet, whereas some of the other folks in the association, their assessments may go up. If you're changing the allocation of assessments, you have to be careful because there could be an accusation that this was done not for the interests of the association, but for the interests of the board members. So conflicts of interest and good faith, those concepts are oftentimes intertwined. Any other thoughts or comments about to whom the duty of care is owed and the standard of care that's articulated in number 2 on this slide? All right, let's move on to the next slide. Again, this is part of how you exercise or discharge that fiduciary responsibility. The statutory provisions make it clear that in order, remember that sentence in the previous slide, reasonable inquiry? Reasonable inquiry. What does that mean? Well, board members are certainly bright folks, but you may not have particular expertise in a lot of what you do. If you're looking at, for example, a renovation project to the roof, even though you may have had some experiences, personal experiences in dealing with roofers, it's very different than working on a roof at your single family residence. Now you have responsibility to oversee and to implement a project for hundreds, if not thousands of units and huge areas of roofing that you may need to replace. Who do you then, other than getting bids, who's going to supervise the work? You, your management company? You need to get advice from third-party professionals. The acts, each of the 3 acts make it clear that in order to exercise your fiduciary responsibility, to discharge that duty, and to make sure that you reduce, and this is important, reduce the potential challenge for your decision-making process. Let's face it, we live in a very litigious society, and there's going to be somebody, I always put up my finger, there's always one owner who's going to complain about what the board's doing. Frankly, you're lucky if it's just one, because as a practical matter, it's likely to be more, but at least one. So you need to be sensitive to and cognizant of the potential challenges to your decision-making process. The best way by far to ensure that you reduce the challenges and the criticism from homeowners, again, because you'll definitely get that reaction, and most importantly, to defend the association in a court of law if it gets there. Hopefully not, but if it does, the best way to fend off the challenges and the criticism is your ability to demonstrate that you have relied, again, in good faith, getting back to that concept, upon the advice of third-party professionals. Who are those third parties? Well, obviously there are lawyers, but there are other third parties, architects, engineers, CPAs, professional managers. All third-party professionals have the ability, because of the nature of their businesses, to provide boards with direction, with opinions, with some supervision of projects. Don't you take it on. Why would you do that? Why would you want to make the decision based upon your gut reaction or what you think is an appropriate decision to hire a particular roofer or to engage in a certain remedial project? Do you do it now? Do you do it another time? These are getting third-party opinions are absolutely essential to insulate boards from potential liability. I think we just had a question that came in. Did we not, Donna or Kristen?
Yes.
You want to read that to us?
Yeah, they want to know how many third-party opinions minimum should you get for any issue?
Well, it depends on the issue. I hate to give you that lawyer's response. It depends, but it really does depend. Is there an example of somebody who posed that question? Do you have a particular war story you want to share with us, or any particular situation that occurred where there may have been the need for more than one? It does depend. I would say typically one would suffice, but not always. It says nothing in particular, say a large repair. All right, so you've got a major repair project. I'll go back to the roofing concept. Do you need to do a total re-roofing? Should there be some spot repairs? Is it time to look at a complete and total replacement project, which can be significant, not only in terms of board's time, manager's time, but from a cost standpoint, you may need to consider financing if you don't have sufficient reserves. What about even the decision to allocate a percentage of reserves to a replacement project? Let's say it's a re-roofing project of $2 million. You have reserves of $1 million. Should you draw down 100% on the reserves to pay for the re-roofing project and perhaps seek financing for the other $1 million? Or do you issue a special assessment? You know, that hated concept. Right now we're going to charge everybody $10,000 a unit or $5,000 a unit, depending upon the number of units, to make up the shortfall. And we're going to commit 100% of reserves. You could, but is that prudent? Is that what a person of reasonable, ordinary prudence would do under the circumstances? Is that an appropriate approach? So who would you want to consult with? Maybe your CPA or your auditor that you've worked with, maybe your professional manager, maybe your attorney, because you may say, you know what, I want to go out and I want to get a loan because I'm going to finance this project. Banks are into these kinds of financing projects today. Rates are pretty good, maybe not as good as they were 6 months ago, but they're still okay. But how do you arrive at that conclusion? Do you even know whether or not your association has the right to finance a roof replacement project? So before you go too far down that road in evaluating that potential option, maybe you seek the advice of your attorney. Mr. Sugarman, are we able to obtain a loan under our documents, or is it prohibited? Or do we need to secure the approval of, for example, 67% of the owners, something similar to a percentage that you might need to amend your declaration? Oftentimes, believe it or not, there are these kinds of roadblocks to what you as a board may ultimately think is in the best interest of the association, but you may not have the legal ability to pull it off because of impediments or obstacles in your governing documents. Secure an opinion from your attorney. Can we go down this road, or should we look at some other options? Talk to your CPA. You know, is it appropriate for us to commit X percentage of our reserves to this replacement project? Or are we better off funding the entirety through a combination of a loan and perhaps a special assessment? Let's keep our reserves set aside for another day, or maybe you only draw a percentage. If you've been allocating reserves for a roof replacement project, maybe you have 100% of the dollars available. Typically not. Let's face it, most reserve accounts are not sufficiently capitalized because it hurts to do so on an annual basis. So you may not be, quote, full funded, as our reserve specialists like to use that term. So, but you might have maybe X percentage. So maybe you take 20% of your reserves, throw it into the replacement project, get a loan for the balance, or maybe a hybrid. We call a hybrid a combination of a loan and special assessment. But these are the kinds of issues that you need to grapple with in order to effectively discharge that fiduciary duty. You need to surround yourself with opinions from third-party professionals. So I would say, to answer the previous board member's question, you can get an opinion from an attorney. I would say one opinion would suffice in this scenario, but you would likely get an opinion from your CPA and maybe an architect or an engineer concerning whether or not the time is ripe to do a full bore replacement project, or do you have more time? Or do you have the ability to stage out the progression of your project? Maybe you do a project over 5 years or longer, do a building a year. These are the kinds of analyses that you need to evaluate and perform, but don't do it in a vacuum. Obtain the report or the opinions from the third parties. And here's really, not only does that make sense and makes all of your jobs a heck of a lot easier. Here's the pièce de résistance. That's a legal term. And that is that if you do those things, you'll love this. The statutes were amended a number of years ago, and we were very actively involved in making this happen through CAI's Legislative Action Committee. But these 3 statutes were all amended, or each amended, to provide that if the board members discharge that fiduciary duty in a manner as described, meaning in good faith, in the best interests of the association, with reasonable skill and due diligence and the use of, quote, ordinary prudence and justifiable reliance upon third-party professionals' opinions, there shall be, and I'm quoting, no liability for the board members. Doesn't mean you can't be sued. Again, as I commented upon earlier in this discussion, there may well be some litigation as to why the board did what they did and how they did it, because again, there's always that one critic, probably more. But if you have followed those particular principles, those standards of care in exercising fiduciary duty, the state statutes now say there shall be no liability. In my book, that's a real good thing, and one of the major reasons why, as a board member, it is imperative that you strictly adhere to those principles and those standards of conduct. Because again, you might be a defendant, named as a defendant in a lawsuit that's very different than being found liable or culpable for actions or omissions that you may have committed because you failed to follow the recipe that's in each of these statutes for purposes of discharging your fiduciary duty. Use third-party professionals. It's not all that expensive. I know board members are very sensitive to the economics, as well you should be. But if it's, get an estimate from the third party, from your attorney, or from your architect. What would it cost for you to evaluate this and give us your opinion? Maybe it's $500 on the low side, maybe it's $1,000 or $2,000. But again, when you juxtapose that number in relationship to the total number for the project, or more importantly, for the aggravation and time and money that you may have to spend defending yourselves as a litigant and named defendant in a lawsuit, there is absolutely no comparison. And you want your lawyer, and I always say this, I'm going to hold up a piece of paper. I'm going to say, Your Honor, this is why the board did what it did. It's the report, because you have every right to rely upon, to justifiably rely upon those reports and the advice of third-party professionals. You can point to that. It's Exhibit A in the defense of the claim, and that is the best way by far to eliminate any potential liability. It also does something else. And I'm sure all of you have served on boards, whether for a limited period or an extended period. And I know it's a tough job. I always say board members have the toughest job, and the pay that you receive is terrible. But putting aside that issue, if you have the report in hand, because somebody's going to say, why did you do what you did? And, I question whether or not you acted in a manner that was consistent with the fiduciary duty. If you don't have the report, what's your response? If you don't have an opinion from a third party, what is your response? Well, we just thought that was the best thing to do. But that's the whole point. The owners who are complaining because they disagree with your analysis, because they believe that you have not acted in a manner that's consistent with the best interest of the association. So if it becomes simply your opinion versus their opinion, that does very little to have a chilling effect upon the likelihood or the prospect of an owner or owners, more likely owners plural, being sufficiently upset that some action is taken, whether an internal grievance process or the filing of a lawsuit, retention of counsel, and then a suit against the association and its board. But if you're able to say, just like I said earlier when I hold up the exhibit to the judge or to the jury, this is why the association took the action that it did. It sought a report. The third-party professional recommended to take this particular direction. What's another instance? Just to put it in real time war story. Architectural requests. Architectural requests frequently serve as the basis for claims against associations where the owners make an application which is denied. Let's say it's putting up a fence or expanding the patio, let's say in a suburban community, expanding the patio area, and the owner owns, it's not common area right behind the patio. They want to expand it a bit, or plant some bushes around the outside, or make some modifications in a high rise to your limited common element balcony, change the color. That's an easier one because that's aesthetics and will be likely controlled by the board. But in terms of some of these, what I call turf wars, we have a case now, it just came in from a carrier through a D&O carrier. Association was sued because it said no to an owner who wanted to modify a retention wall and add a higher wall in the area to the rear of the unit. Again, a horizontal suburban community. Well, the board said no. What's the best way, even prior to the initiation of that suit, what's the best way to convince that owner that what the board did was the right call in saying no to that application for the modification of a retention wall? Hire an engineer. Engineer comes out, takes a look at it and says, no, you should not modify. The wall's working fine. And in fact, if the modification that's proposed is made, it could have a deleterious impact upon stormwater management to the rear of the home, or adversely affect the adjacent home. It might be okay for the immediate owner who's the applicant, but it could have a detrimental or adverse impact upon the row of units, down through the balance of the building. With that in hand, you're in a much better position to be able to support the no. And guess what? If your documents don't already provide for it, have the cost of the engineer tacked on as an expense to be borne by the applicant. Certainly permit it. You have an obligation to evaluate the application. If you need to have third parties evaluate to provide guidance, have that as part of the charge incident to the application for approval. So again, many more positives. The only real negative, candidly, would be the expense. But if you can pass that on to the owner, then it's really not an issue for the association. But at the end of the day, absolutely surround yourself, literally and figuratively, with third-party opinions, because by far it is the key element in not only demonstrating your discharge and your effective discharge of the fiduciary duty, but in defending any potential claim that might be filed against the association and its board. I've been talking a lot more than I had wanted to, so questions, comments about what we've covered so far. Any experiences in dealing with third parties? Has it worked as effectively as I've suggested, or have you encountered some pitfalls or problems in securing those opinions from third parties? I heard somebody. Okay. If there's no further comments on the what I call the application of some fundamental principles in order to satisfy your obligations, we can move on to the next slide, Chrissy. So there's this concept of.
Steve, excuse me real quick.
There we go.
There's actually a question in the chat.
Go ahead.
Our community is located in New Jersey. What are the laws in New Jersey that would be comparable to the ones mentioned in New Jersey?
Well,
In
first
PA.
response, I am not a New Jersey lawyer. So I would have to defer to my colleagues on the other side of the river. I can tell you that from my experiences over the years and dealing with folks in New Jersey, as well as lawyers, that by and large, they are substantially similar concepts in New Jersey. I just don't have the same knowledge as to the statutory provisions and any amendments to the statutory provisions. But the notion itself of fiduciary concepts that we've been discussing, the general guidelines, I am confident would be equally applicable to issues in the state of New Jersey. I did see another question that came in.
It says, Steve, can you there's a couple coming in, sorry. Steve, can you explain how and if boards are protected even when the best outcome is not achieved, even when they did defer to third-party experts?
Well, I said a few moments ago, we cannot guarantee that if you follow the concepts that we've been discussing, that you won't be sued. But I can tell you with great confidence that if in fact you adhere to these principles and follow them rigorously and closely, that there is a high likelihood that the trier of fact, be it a judge or a jury, will ultimately conclude that you have satisfied your obligations as a fiduciary. In other words, that you have properly discharged those obligations. And if that's the case, and if that conclusion is correct, then as I pointed out, at least in Pennsylvania, the statutes now all provide that there shall be no liability. And so in a trial setting, a judge would have the opportunity to actually find in your favor, even before the issue would go to a jury, in what's referred to as a motion for a non-suit. If I were defending a board and I could demonstrate to the trial judge that the board adhered to all of those standards, got the third-party opinions, even if the third party was wrong, and this is what's so great about this whole concept, that everybody can play Monday morning quarterback and second guess the decision and even second guess the opinions that have been provided to the board. But even if at the end of the day, some expert comes to the conclusion that your expert, whether lawyer, architect, engineer, may have erred, that doesn't matter with regard to your reliance, because you still have the right to rely upon the advice of those third parties. So even if someone determines, judge, jury, arbitrator, mediator, that the opinions may not have been well presented or rooted in proper fact or law, if you had a reasonable right to rely upon that, meaning that you felt that the person or persons to whom you referred the matter were reasonably competent and knew something about the subject matter, For example, you went to a lawyer who has some expertise in the community association field, as opposed to getting advice from a personal injury lawyer. I'm not being critical of my colleagues who practice in that field. It's just not their thing. So you may be questioned as to, well, why did you go to that lawyer and not someone who had some expertise? Likewise, with regard to architects and engineers. They all have their own particular areas of expertise. So if you have a structural issue, water leakage into a garage, you may want to go to a structural engineer that has some expertise with water penetration problems, as opposed to an architect that might design single-family homes, but has never dealt with at all in his or her years of experience with water penetration problems involving subsurface garages. So that's why you still need to call in third-party personnel that have some reasonable experience dealing with the subject matter at hand. But if you have that person or persons and rely, even if ultimately they're proven to have made an error, that does not change the insulation factor. It does not change your ability to stand behind their recommendation. And you can continue to hold up that report and say, this is why we made that determination in reliance upon the advice of the third party. Was there another question, Chrissy?
Yeah.
Yeah.
It's what should you do if a contractor says there's only one type of contractor who performs a major type of repair restoration? I had to push, and the contractor finally admitted that there's only one other contractor, but in another geographical area.
There's only one contractor?
Yes, and there's only one type of contractor who performs a major type of repair or restoration. I had to push, and the contractor finally admitted that there is one other contractor, but in another geographical area.
Well, I mean, I'm a big advocate. If you're talking about getting bids, competitive bids, that's part of discharging the fiduciary responsibility. However, if you ultimately reach the conclusion because of efforts made, as long as you put in the effort, either through professional management such as CAMCO or on your own as a board, in trying to obtain bids, if you've made a good faith effort and you only secure one bid, and the reason being is that there's not a contractor or enough contractors who are interested in the job, either because it requires a particular expertise or materials or equipment that may not be readily available to the contractor, or they just don't have the experience, you are certainly permitted to go with one or two competitive bids rather than the standard three. Again, not as desirable a situation, but that's where you have to evaluate and apply, as in here, sound business judgment, and determine whether it makes sense for you to hold off on doing the project in order to obtain a second or a third bid, and then risk the fact that you're deferring this project, and at the end of the day, it may cost you a lot more money, and therefore it may be more prudent and it may be more appropriate for you to simply contract with that contractor who is willing to and does have that expertise to perform the project at hand. Sound business judgment is a corollary to the whole concept of fiduciary duty. It's really a judicial rule of deference, again, in a litigation mode, that if you can demonstrate that you acted within the scope of your authority and you made the decision in good faith without fraud or any kind of self-dealing, at least in Pennsylvania, and I believe in the state of New Jersey as well, although I'm not 100% sure that the business judgment rule is alive and well. I suspect it is. It's a common law concept that's been around for decades. Then you will have the ability to persuade a judge or a jury that you have satisfied the requirement for exercising your sound business judgment, and your decision would likely stand. There's also at the root of a lot of the decision-making process, and while it's not necessarily front and center in some of the statutes, I can tell you from a practical standpoint that if you're able to demonstrate both to your members and, if you need to, before a judge or a jury, that you have exercised your fiduciary obligations in a reasonable fashion, that your decision-making process was reasonable. And again, that's kind of a slippery slope. I get it, because what does that mean? That's the stuff of litigation. But I can tell you, having appeared before many trial judges, that judges will be much more inclined to affirm a decision-making process that was exercised by a board or discharged by a board if you can demonstrate that the board acted in a manner that was reasonable. It made good sense. As I often say to the law students that I teach, don't leave your common sense outside the courtroom, because common sense and what works, I mean, we're all, at the end of the day, we're all looking at these issues from a human perspective. We might be lawyers or architects or other professionals, but a judge and a jury is going to see, well, did it make sense for the entity? Was it a good thing to do? Was it fair? Was it reasonable? So don't ever forget those concepts and apply those in your decision-making process as well. I think we had another question that came in. Yes, Chrissy or Donna?
Yes. How do board members protect themselves if they are in disagreement with other board members who they believe are not making sound business judgments?
Well, a couple of ways. That's a really good question. And thanks for that question. Number one, I would suggest that as a board member, you register your opposition in your board meeting minutes. You make a specific request that I want the secretary to note my opposition, and then lay out the reasons for the opposition. That may ultimately protect your interests if the board is brought before a court or an arbitrator to decide whether or not they acted as fiduciaries. So I would definitely want to see that position memorialized in meeting minutes. Remember too, that the attorney is representing the entity. Just like you owe a fiduciary obligation to the association, legal counsel does not represent you as board members. I know that's sometimes kind of a tricky concept, because you say, well, wait a minute, we deal with the lawyer, we pose the questions from the board to the association's lawyer, we get opinions and advice from the association's lawyer directed to the board, all true. But insofar as the allegiance and the duty of loyalty and the attorney-client relationship, it's between the association and the entity, whether unincorporated association or a nonprofit corporation. So the attorney cannot actually give legal advice to individual board members who may have some concerns about the process. The attorney can chime in about the process, but the advice is given to the full board. If you as a board member feel like you need to go further, that you believe there may be some, either a crime being committed or some fraudulent conduct, or contrary to the sound business judgment rule, some type of self-dealing, some kickback that might be taking place, you hire Acme contractors, and there's a deal that the board president or some board members are getting a piece of the action, if you will. Scary thoughts, but these things do happen. Fortunately, not with any regularity, but they do and can happen. If you as a board member get wind of this and you feel as though your objection memorialized in the minutes is not enough, then you may wish to seek your own counsel. I would certainly bring it to the attention of the association's lawyer, but you may also wish to retain and engage your own legal counsel to represent your interests as a dissident board member. There's nothing that prohibits that. In fact, it's generally a good idea if you want your views expressed in a more potent and effective fashion. There may be some merit in securing your own legal counsel. I think there were some more questions that came in.
Yes. If a shareholder asks to meet with the board because he or she doesn't agree with a decision, is the board obligated to meet with that person?
So if a member of the association
Wants to meet with the board because they don't agree with the decision, is the board obligated to meet with that person?
Well, there is not, unless the documents otherwise provide, and typically they do not. If you're making a decision that impacts a particular owner, whether it's an application for architectural approval, whether it's an assessment collection issue, and maybe the owner has applied for some type of a installment payment plan, and the owner and the board says no, and the owner wants to be heard. As part of that decision-making process, there may well be value in having the owner attend a board meeting and to be heard. And certainly in the case of the board applying fines or making a determination that there's been some type of violation of the governing documents, before you would impose or levy any fine, you are statutorily required to permit the owner to be heard by the board or the architectural review committee, whichever entity has the authority to levy fines. You cannot levy fines without providing that standard due process procedure, notice, and an opportunity to be heard. But if it's outside the scope of a fining procedure, or you're taking away some rights from the owner, and it's just part of the normal decision-making process, unless the documents otherwise require a sit down or a meeting or an opportunity to be heard, there isn't a legal requirement. That's from the legal perspective. From a practical standpoint, my position typically is, and my general advice to boards is that if an owner wants to be heard, then you should provide an opportunity for the owner to be heard. Very little downside other than the time that you have to make for your busy agenda that evening or that afternoon for your board meeting, and a huge upside. Because again, if owners are being impacted by your decisions, and especially if they're being impacted adversely, they may well want to be heard to voice their position or their opinions. Provide that opportunity. Only good things typically happen, whereas if you say no, it makes it look as though the board is being dictatorial and is not giving an owner an opportunity to be heard, which is usually frowned upon, not just politically within the community, but I can tell you if the matter percolates into a judicial arena, a judge isn't going to be real happy by that either. Other questions, Donna?
I don't see anything else, Steve.
Okay, if not, I'm very sensitive to the time, and let's just kind of, Chrissy, if you don't mind, or Donna, if you're operating the slides, there is a topic that I know is very near and dear to many of us now. Let's go to the reserve slide. I do want to touch upon that. Here we go. You know, as a result of the Surfside Condo collapse, your Champlain Tower South, there's been lots of discussion, and for good reason, about reserves, about inspections. And I thought we should spend just a few minutes, and I know we're kind of crunched for time, but I'll try to be brief as best we can, but it is an important topic. First of all, with respect to reserve funding, there is no statutory requirement in Pennsylvania for setting aside reserves or for conducting a reserve study. It is not in those statutes to which I referred at the outset of this discussion. It's not there. So you may ask, well, then why bother? Well, number one, it's certainly consistent with the previous slide I showed you about exercising sound business judgment. As you can well appreciate, you're running the affairs. In some instances, there's certainly multi-$1,000 budgets, if not $1,000,000 budgets for many associations. You have to apply sound business and prudent business judgment. Why wouldn't you set aside funds to take care of future major repairs and replacements? Those are the buzzwords, by the way. Reserves, future major repairs and replacements for reserve allocation. But as in number 2 here on the slide, most governing documents, typically the declaration, requires reserves. Usually says something about that the board shall set aside on an annual basis as part of its annual budgets a reasonable amount of reserve funds. So even though it's not in the statute, it is typically embodied within the 4 corners of your governing documents. And again, usually the declaration, sometimes the bylaws. How often should you perform a reserve study? Any idea? Donna, what do you typically recommend?
3 to 5 years.
3 to 5 years. And I would agree with that. 3 to 5 years. Again, money well spent. You need to know, where are we in the ultimately anticipated, expected, useful life of major components? Because you do not want to be saddled 5 years from now and having to go out and try to get some type of loan. How I say having, you may decide it's in the best interest because it may be desirable to finance a replacement project. But you need to be able to satisfy your fiduciary duty by at least demonstrating that you're allocating some reasonable amount of reserves. Again, does it have to be full funding? No, but it has to be funding that's at least reasonable to accommodate the ultimate future needs of the association. And if in fact it's likely that you're going to have a shortfall, what's the best way to not eliminate, but at least to mitigate or minimize the prospect of liability? Disclose it. Disclose to the members. We are not full funding 100% for the useful life of the roof or the siding, because it would be cost prohibitive. We don't want to increase the amount of the monthly assessments to such a degree where it's just undesirable, because there's a balancing act, right? You have to preserve and protect the fair market value of your units. That's part of your fiduciary duty. It doesn't say that, but that's really what we're talking about here, to preservation of the values of the units and your common elements. And so if you increase your monthly assessments to such a degree that it's so undesirable for resales, you're going to have a problem with market value. So I get it, and you get it. There's going to need to be a healthy balance. But if you are underfunded and know it, you should tell the homeowners, we're trying to increase as we can, as we go along. We have a shortfall, but we're going to be doing whatever we can to increase those funds. And hopefully the useful life of some of these major components will extend a little bit beyond what we're being told, and we'll have sufficient revenue, or we'll have to resort to the alternative approaches, i.e. financing or the special assessment. 3 to 5 years certainly makes sense. If you become aware of potential deficiencies, as was the case certainly in Florida, you do not, if any lesson is to be learned from that horrific tragedy, if any lesson is to be learned, it's you cannot set it aside and kind of hope that in the future, you'll be able to tackle some of these issues. At a minimum, make your inspections, get the opinions from third-party professionals, evaluate what you can do and when you should do it, stagger your dollars in your reserve funds so that you have at least a reasonable amount that could be applied not only for certain unforeseen expenses that may be required, but for those that are clearly foreseen and documented by your reserve specialist. Why get the reserve study? To help guide you and protect you from third-party liability when the homeowners say, why didn't you set aside certain funds? Because, well, we didn't know that we should have done that. If you've got the study and you have reasonably relied upon the study, just like we talked about before, there shall be, quote, no liability. Any thoughts or comments about reserves? I know it's a difficult topic, especially because of not only the recent tragedy in Florida, but a lot of homeowners just conceptually aren't real comfortable. I remember I had one community that said, don't worry about reserves, Steve, because we'll just cut a check if we need to make a payment, 2 to 3 to 4 or 5 years from now. Well, not everybody can do that. And nor is it necessarily appropriate to do that, especially because we're going to see more and more in resales. Guarantee this is going to happen. Let's look at this from a standpoint of looking in the crystal ball. Although I always say if that I really knew what was going to be in that crystal ball, I wouldn't be practicing law. But I can still tell you that from a standpoint of what we see that is coming out of the Surfside tragedy, you're going to see buyers. We already have Fannie Mae, FHA, that's making requirements. I'm sure you're dealing with that now from a management standpoint about more intense disclosures of conditions of your property. Those disclosures are scary. I can also tell you that in my professional opinion, you're only looking for or inviting trouble by completing them in the form that they are currently in. And you should consult with your legal counsel if you've got a resale where you now have a disclosure requirement from FHA, Fannie Mae, Freddie Mac for your mortgagee disclosure form. Be very, very careful because, as I say, it can invite liability. But that's just from a governmental standpoint and the financing standpoint. I can assure you, you're going to see buyers, at least sophisticated buyers, and certainly in some of the communities in which many of you live, that you're going to a resale, you're going to get buyers that are going to be looking for reserve studies. Whereas historically, it's just a resale certificate. But I anticipate we're going to see more and more requests for actual production of the reserve studies for the opportunity to further investigate the financial wherewithal of the community to address the potential deficiencies, or that hated concept of deferred maintenance. Many community associations engage in that. Some communities have separate budgets for deferred maintenance. So you need to very closely scrutinize, again, what's in the best interest of the association with regard to applying reserve study analyses, work with a reserve specialist, work with management such as CAMCO to come up with the best scheme for your community to address reserves. I think that's going to be a very fertile turf for litigation in the next several years. Other issues, questions? Then the last slide, if you won't mind, Donna or Chrissy. Just some concepts to think about after this evening's program, what I call the best practices. Act promptly and consistently. Again, B, advice, act on the advice of third-party professionals. C, act upon the facts revealed during investigations and part of your due diligence. Don't speculate, do the investigations, preferably again with the third parties. And D, number 4, bottom of the list, but arguably should be at the top, act reasonably. And if you're not comfortable with this, with your decision, there's a reason why you're not comfortable. So make sure you inject your decision-making process with these best practices. And I'm pretty confident that not only will you feel good about that process, you'll be able to demonstrate to your members that you achieved the proper exercise and discharge of the fiduciary duty. And significantly, if you have to defend yourself in a courtroom or before an arbitrator, you'll likewise be able to point to these same factors and in all likelihood, avoid any potential liability from your acts and or omissions. Other questions? It looks like we have another one that was just raised.
Just thank you. Great information.
Okay. I'm sensitive to the hour, and I know again that we have other things to do certainly, but I am available. I'm happy to stick around if there's some more questions about this concept. Any issues or concerns, any war stories you want to share, now's your opportunity, and I'm happy to be as responsive as I can.
Did you see anything, Chrissy? I don't.
No, just thank you again for the information, most helpful.
Great.
Well, thank you, Steve. I appreciate it. Is there anything else, Chrissy?
No, you're good.
Okay. Well, Steve, I want to thank everyone also for joining us. Thank you, Steve, for a great presentation.
Thank you.
This was recorded, so if you would like to have the recording, any of our board members, certainly drop me an email and we'll forward that recording to you. And our next roundtable is actually March 1st on board members' best practices. And I'd just like to thank everyone once again for attending this evening. And thanks again, Steve. I appreciate it.
And thank you.
Great job, Steve.
Good
Thanks very much. Nice